Please face the flag of our nation and recognize the principles for which it stands. Department 81 is now in session. The Honorable Mark E. Window, Judge, presiding.
Please be seated, everyone. Good morning.
Good afternoon.
Good morning. All right, calling the case of People versus Robert Durst. Mr. Durst is present with Mr. DeGuerin and Mr. Chesnoff.
With your permission, Your Honor, hearing for Mr. Ray and Mr. Rios.
Mr. Lewin.
John Lewin for the people, Your Honor, along with Habib Balian, Ethan Milius, and Eugene Miata.
All right, we're here for a couple of matters. First of all, we have the motion, or rather the objection to portions of the recorded interview of Mr. Durst by Mr. Lewin. And I have read and considered the objections, and we've had extensive argument already about part of this. But let me just give you a tentative that will guide our discussions. I had invited objection under Evidence Code 352 to portions that were more prejudicial than probative, but I did receive objections on that basis, but also a claimed invocation of privilege and a claim that statements would be or should be excluded under 1153 of the Evidence Code in People versus Tanner. So, to be clear, my tentative would be to deny the objections or overrule the objections upon the claim of an invocation of privilege. All of those objections, because I don't believe we've already argued the Fifth Amendment here. I reviewed it again. This is not a 352 objection. It's a claim of privilege, which is unsupported. See the argument regarding plea negotiations, 1153 of the Evidence Code. And I've looked at each of them. That seems right. I do think each of those should be excluded, not only under 1153, but also under 352. And then, as to the objections under 352, I think my rulings would vary. We really need to go through each and every objection to analyze them. So I'll hear you out. I'll hear the defense and the people on the first two items, the idea that there's an invocation of privilege, and in each case it's simply a refusal to answer questions, specific questions, rather than an invocation of privilege, as I see it. And I think that a refusal to answer a question after agreeing to be interviewed is not the same as asking for an attorney. It's just it's probative. It's a refusal to deal with some very pointed questions, and I think that is relevant. But I'll hear you out, Mr. DeGuerin.
Well, on that point, Your Honor, the warning that Mr. Lewin read or recited at the very beginning mentioned that he had the right to stop the questioning at any time. He had the right to refuse to answer at any time. And there are several occasions, which I've identified in the objections, in which I think that he invoked that right. He can do so selectively, I believe, not on the witness stand, but he could do so selectively by saying, I choose to remain silent on that, or words that are the equivalent of an invocation of his right to remain silent. And that's what we've identified in the record. I can go through some of those and identify them, although they're identified in our motion.
They're identified in your moving paper, so the idea here is you're I don't know if there's authority for focused waivers, focused invocations, depending on the nature of the waiver at the outset. Clearly, at any time, he could request a lawyer, he could refuse to participate further. But what you're claiming is that one can selectively invoke as to particular questions, and that this should be excluded from a jury's consideration. I don't know of any authority for that idea, but I'll hear you out.
My reasoning, Your Honor, is that it's a very soft, if waiver at all, because at the very beginning, he's not asked whether he would waive his rights as were read to him, but simply whether he would listen to Mr. Lewin. And Mr. Lewin then goes into his questioning and his recital of what Mr. Lewin already claims to know, and his statement, Mr. Lewin's statements of fact that his investigation or other investigations have shown. Of those, of course, we're objecting because there are statements that we can't cross-examine, Mr. Lewin's statements of fact. But what Mr. Durst does is when he feels it's appropriate, and in various ways, he says, I don't wish to talk about that. That's an invocation of his right to remain silent. For instance, on page 13, line 23, the words that he uses is, I'm going to stay away from killing Susan. I'm not going to talk about that, in other words. On page 14, I'm going to stay away from that. Mr. Lewin then asked him, is that something you're comfortable answering? No. That's an invocation of his right not to answer questions. And to allow the question itself and then his refusal or his invocation puts a price on his invocation of his constitutional right to remain silent.
And what is the specific language that you believe makes this different from an ordinary advisement of Miranda rights? You call it?
Well, it starts at the very beginning when there is a discussion of what his rights are. Let's see if I can find it. It begins about page 7, toward the bottom of page 7. You have the right to remain silent. Do you understand? There's no response. You have to acknowledge me. I understand. Anything you say may be used against you. I understand. You have the right to the presence of attorney. This is now on page 8. Do you understand? If you cannot afford an attorney, you get one. I understand. So with that, we would like to ask you some questions. Do you understand the rights you've been given? Yes. So at this point, I'm just going to start. He doesn't say, do you waive those rights? He doesn't get an affirmative waiver of the rights.
Right.
But nonetheless, those rights are in other words, still in effect. He hasn't waived his rights. He's sitting there listening to what Mr. Lewin says, and as the court knows and as the transcript shows, and most of the talking is done by Mr. Lewin, and assertions of fact and assertions of opinion.
This is, and we'll get to that part, but it doesn't seem any different from any other implied waiver case. There's nothing special, there are no special conditions, no special warnings or privileges that are extended, there's no negotiation. It's simply a matter of telling Mr. Durst what his rights are. Mr. Durst acknowledges what his rights are, and they have a conversation. Some questions he doesn't answer, he says, I don't want to talk about that. I don't think that's an invocation. But anyway, let's hear the other. Do you have anything to say about the 1153? I agree with you. So I would exclude, so you probably don't
If
need
you're
to comment
agreeing
on
with
that.
me, I'm gonna shut up.
Right.
Unlike some other people in this.
Well, we'll see. Mr. Lewin hasn't said that they haven't heard a peep out of him yet.
No, I'm not speaking of past in the history. Maybe things have changed.
Things have changed.
I'm not certain, but, no, sir.
Okay, thank you.
I think you're right in agreeing with me about that.
So, Mr. Lewin, do you anything to add on the claim to invocation?
No, nothing.
And then on the 1153,
Yes.
you want to talk about that?
Yes.
And there's two grounds, 352 and 1153, but go ahead.
Your Honor, so I want to start again. This is very important, and we have litigated this statement. I believe this is the 7th time we've litigated it. And if we look at it, Your Honor, the court made very clear. The reason this came up is the court made an offhanded comment. During the interview, I said in essence to Mr. Durst, you know, Mr. Durst, the reason why I win my cases is because the defendants are guilty. And the court absolutely legitimately said, hey, you know what? That shouldn't come in under 352. So what the defense was supposed to do was to note under 352 what was coming in. Instead, Your Honor, what they did was they filed 7 months after the deadline for the court originally for them to have filed their motions. They filed yet another motion, and they bring up, number one, invocation, which is a Fifth Amendment right, which we've already litigated, okay? 2, 1153, which is not 352, which does not come in any way, shape, or form, have anything to do with the reason why we're here, but I'm now going to discuss 1153 in a moment. And then they have an area, Your Honor, that they call, in essence, facts and assertions. There's, in their whole, if you want to call it a motion, Your Honor, they cite one case in the entire motion, and that's under the 1153 area. And that case, Your Honor, is 40 years old. They ignore all the other authority that's out there. And so I'm going to start with 1153 because I think that's what the court is looking at. So let's, first of all, let's look at what 1153 is supposed to prohibit.
Well, the Tanner's a lot broader than 1153, because 1153 seems quite narrow. It's talking just about an offer to plead guilty,
Well,
or a plea of guilty, and
well-
that's not what's happening. So Tanner really seems to expand it, and it seems to still be good law.
well, the problem, you know, I'll go through it, but they actually cover, they talk about 1153, 1192.4 in Tanner. 1192.4 obviously doesn't apply legally and factually, so that makes no sense. But let's talk about Tanner for a second. What Tanner says, Your Honor, is that in essence, let's look at what Tanner involved. Tanner involved letters being written to the DA and the deputy DA by a defendant while he was in jail after he had been charged and it was awaiting trial. And what the court said in Tanner is they said, listen, 1153 extends not only to pleas of guilty or offers to plead guilty, but also prohibits the use of admissions and incidental statements, and this is the key part, made during bona fide plea bargaining negotiations in the prosecution's case in chief. Now, what are bona fide plea negotiations? Well, Tanner cited People v. Wilson at 60 Cal 3rd 139. And
Go ahead. Sorry.
And Wilson again went back and talked about specifically how you want to encourage settlement of criminal cases without the necessity of trial. However, Your Honor, there is no case out there, anywhere, that has ever applied 1153 or this theory to an unfiled case. And if you think about it, Your Honor, you can't have plea negotiations over a case that hasn't been filed yet. And in fact, every one of the cases that's out there, we can move on. We can talk about Leonard by our Cal Supreme Court in 2007.
I think these guys do it all the time.
Yeah.
Yeah, I mean, PD doesn't because they don't get the case till arraignment, but I mean, these folks, they'll go in, that somebody's been, someone's being investigated for a case, they'll come in and try to negotiate before it's even filed.
Well, Your Honor,
I think that's typical. There may not be a case, but it does happen.
fine, let's discuss that scenario.
Yeah, yeah.
In that scenario, Your Honor, first of all, we're not talking about what a lawyer said, we're talking about what the defendant said. And in those scenarios, Your Honor, and it's very clear, what happens is the defendant is advised either that nothing he says during these negotiations or discussions, that he has basically use immunity for that conversation, or he doesn't. When he doesn't, it's used. Now let's back up. Mr. Durst was told when he was Mirandized that everything he said can and will be used against him. So the first problem is, if we look at 1153, let me talk about Leonard because it's important. In Leonard, Your Honor, it's 40 Cal 4th, 1370 at 1404. And in this case, they said, we agree with the trial court that defendant's in-court outburst declaring that he was guilty was not a bona fide offer to plead guilty. And that's what it was about. And the court went on to say, defendant did not say he wanted to enter a plea of guilty, that is, to formally admit that he had committed each of the charged crimes. Rather, he said he was guilty without explaining what he was guilty of. No plea negotiations were underway, and to include statements of this kind would not encourage the settlement of criminal cases. Cummings, 1993, 4 Cal 4, 1233. In that situation, again, we had a pretrial interview of a charged defendant with a prosecutor, an investigator, and a detective. During that time, the lawyer, Shin, sought to arrange a polygraph examination of Gay, and he hoped that if Gay passed it, that he'd be able to testify as a witness. Gay had asserted his innocence, etc., throughout the charges. It was agreed that a plea bargain would be arranged only if Gay also passed that polygraph. The prosecutor assumed that Gay was going to deny everything. Instead, he basically got up, he was advised everything could be used against him, and he ended up admitting to basically the entire crime. The court found the statement was not made in the course of plea negotiations, but as a precondition to initiation of the discussion of the charges, etc. I want to talk about two more cases because they're important. One is Poston, 1980, 108 Cal 3rd at 633. And again, this is an appellant who contends that offers to plead guilty made by police while he was being returned after charges had been charged. That again, those were bona fide plea negotiations. The court said no, these offers were not made in the course of bona fide plea negotiations, but were merely unsolicited admissions by appellant without any understanding that they would be inadmissible. Now that's going to be crucial, Your Honor, because in this case, not only is this an unfiled case, not only are these not bona fide plea negotiations, but Your Honor, I'm not the one that brought the issue up. Mr. Durst, on his own, brought up, and I'm going to get to that in a moment, but I just want to talk briefly about the last case, which is Magana. Magana is at 17 Calap 4, 1371, and it again makes very clear that it applies only in the context of bona fide plea negotiations. And it basically talked about, again, this was a filed case, unlike the case we have before us. In addition, Your Honor, if you look at Prop 8, Prop 8 abolished People versus Tanner's judicially created exclusionary rule. So even if the discussions in question were considered bona fide plea bargaining, Prop 8 abolished the Tanner rule anyway. So the bottom line, Your Honor, is even if the court were to find that 1153 applied, you can't get past Prop 8. But we don't even need to go there.
Was that, I'm sorry, is there a citation on Prop 8 abrogating Tanner? Do you have one for me? I mean, it makes sense to me, but do you have a citation?
I believe, I'm gonna have to look, Your Honor. I believe it's going to be in Magana, but I can't tell the court for sure. Again, the problem that we have is that the way that I handled, and the court had agreed previously, when the defense files motions which are not supported by legal authority, or are a repeat of motions, what the court told me months ago is, Mr. Lewin, you don't need to respond to those motions. If we've litigated them, I read them, you don't need to respond again. So, Your Honor, I will have to take a look. I don't know if the authority specifically says that Tanner is abolished by Prop 8, but Your Honor, if you look at it, if you look at Prop 8 and you look at the authority, what Prop 8 means, you cannot have independent state grounds as a means for exclusion of evidence, unless with very limited exceptions, which get very technical, and I know the court's aware of. But I want to go, the court doesn't even have to go there. Because, Your Honor, if we take a look, there is no way that what happened during that interview could in any way be characterized as, quote, bona fide plea negotiations. All right? And let's look at why. One, the case is uncharged. So I want to make sure the court understands, Your Honor, you would be the first court in the state of California to apply 1153 to an uncharged case. They're just not out there. That's number one. Number two, Your Honor.
This case may be unique in a number of ways, though.
I don't think the court wants to be unique in that way, though. I would think.
As long as I see him.
Your Honor, and listen, Your Honor, I think one of the problems is that the defense, in their motion, did not give the court authority. They filed a motion that wasn't about the subject we were supposed to be litigating, and they didn't really give the court the proper authority to really analyze the situation the way it needs to be analyzed. But let me continue, Your Honor. So if you look at what happened during this interview, what occurred was that Mr. Durst ends up on his own. This is at page 23, line 13. He says, going forward, I'm told my life expectancy is about 5 years. So there's not much that I could agree with anybody that somebody could offer me unless they could offer me more life. I respond, right. He says something like that, but there's just one much I can say, listen, look at this. I just have no idea how we could reach an agreement on something. I said, well, let me ask you this, and again, I'm going to speak hypothetically so you don't feel like. He says, if there's something that I could do that would be worthwhile for somebody else, and they could do something for me, then you know there'd be a direction. But I don't see much direction. Your Honor, he brought this up on his own after being told everything that he says can and will be used against him. It's an uncharged case. And just think of the precedent that you're setting, Your Honor. Just think of this right now. The precedent that you would have is now during an interview, wherever there's a discussion, where a defendant says something to the effect of, well, tell me, if I tell you what I want to know, what can you do for me? In an uncharged case, in an unfiled case, outside of a courtroom, with no lawyers present, with no legal argument or discussion taking place, and we're going to say, that's bona fide plea negotiation? Your Honor, that's setting a standard that is absolutely unsupported by the law, and it doesn't make sense. Mr. Durst was specifically admonished that he didn't have to talk to me. He decided he wanted to talk. He himself brought up this issue. And Your Honor, the reason the defense wants this out is it is incredibly probative because it is incredibly damaging. And here's why.
No, I see it's quite damaging.
There's no way that the defense can argue, in essence, well, wait a minute, this really isn't a big deal, because Bob Durst is basically on his own saying, hey, listen, if I tell you what you want to know, what you want to hear, if I give you that information, what can you do for me? And of course, the argument is, if Mr. Durst didn't have that information to give, he wouldn't be saying this. So, Your Honor, to keep this out is absolutely, we do not promote getting to the truth of what occurred, but more than that, we almost, bastardize 1153. I mean, you're now going to say that a defendant on his own can initiate plea proceedings in a case that isn't even filed yet when he brings it up? There's no way. So let's continue. If you look, Your Honor, and you go further, not only were there no formal plea negotiations, no charges had been filed, but quote, whatever he said, these quote negotiations did not result in any admission by defendant, but rather failed to arrive at any agreement. In other words, the defendant offered, this is not a situation where, in essence, I brought up, hey, listen, Mr. Durst, here's the situation. You're charged with this crime. And this would happen post, obviously, Your Honor, post-filing. You're charged with this crime. If you do this for us, here's what we can do for you. And in that situation, you could say, hey, wait a minute, this is a filed case. At that time, almost always, the lawyer would be involved. If you notice on these cases, Your Honor, every one of them involves either an outburst in a courtroom or something that a defendant is sending unsolicited on his own after he's filed. And none of them result, Your Honor, none of them, in fact, they're being deemed that it was, in fact, bona fide plea negotiation. So if we continue, if we go to the specific objections regarding this area.
Maybe the problem I'm going to have here is that there's been a vague claim.
Okay.
The defense has made a claim that should be excluded under Tanner. I read Tanner, I read 1153, seems to apply. Tanner appears to be good law. And yet it appears that with looking a little deeper, there are some contrary authorities to this proposition that have not been briefed. So I'm not going to decide that today. I'm going to have to decide that tomorrow, tonight. I mean, I need to do a little bit more work because I have not been given these arguments, and I understand why you didn't present them to me earlier, but you're presenting them to me now, and I think it's a good. I mean, everyone views it, I suppose, as a slam dunk, a clear cut from their perspective, but from my perspective, it seems like I need to work on this. I'll let you go. I just want to use our time productively, and I don't mind you going into the particulars of each specific objection. I'm wondering if our time might be better used on the 352 aspect.
Well, Your Honor, I think it's so important. I mean, again, Your Honor, this statement is crucial to our case, and we keep litigating it.
That's why it deserves.
So, Your Honor, then our position would be if we have to come back tomorrow to continue this hearing, then we come back. I mean, we need to make sure that this is dealt with. But I want to go back, Your Honor, very important, to the court is saying under Tanner. If you just look at Tanner, the problem with Tanner, Your Honor, is that it's easily distinguishable, and distinguishable not on technical grounds. Tanner, Your Honor, is a guy who's already been charged, who is sending letters to the DA trying to negotiate at that point in time. He's a charged defendant at that point in time.
And he's sending letters, so he's initiating it.
So he sends these letters, and what they said is, in Tanner, they said that it does not apply, this section, unless and until you are talking about bona fide plea negotiations. So the problem is Tanner doesn't even support. But if we go, I mean, Your Honor, I've explained it would be hard pressed when you're looking at this to, even in the cases that are out there, every one of them is a filed case. Even if you want to say, well, the case wasn't filed, I don't care about that fact.
Well, I need to know why does it matter that a case is
Well,
filed? You're telling me that that's a.
Well,
let me ask. You're making a distinction. Is this a distinction that makes a difference? And I want to know why it makes a difference.
Your Honor, here's
that it's
why.
filed versus not filed.
Well, Your Honor, here's why. Very simple. How can you have bona fide, quote, plea negotiations on a case that hasn't been filed yet.
We do it all the time.
No, you cannot have plea negotiations on a case that has not been filed, because you don't even have, at the time I interviewed Mr. Durst, and we've been through this, Your Honor.
So I think the difference here is there's a perception difference. 'Cause I believe in the federal court, as I understand it, that this happens quite often, and in state court, perhaps not so much. Although I've heard of it happening in state court as well. So you're asking that question, how can it be bona fide if nothing has been filed? But certainly one can anticipate the charge here would be murder, and what else would it be? So I can imagine that there could be a bona fide negotiation. Is this that? That's your question.
Right, but Your Honor, in that bona fide negotiation, you would imagine it's going to involve his attorneys. It's not going to be the first time you're sitting down with Mr. Durst as an investigator, prosecutor, and I'm interviewing Mr. Durst. At the time, I'm trying to figure out what information I have. So how on earth can that be characterized as a bona fide plea negotiation? And then you add to the point, he's the one who brings it up, and he brings it up, Your Honor, after he's specifically told anything you say can and will be used against you.
And I think that's a stronger argument for the people, so that's, I'm getting that one and less the other, but that's fine. As I said, this dispute is new to me now, and I don't like to shoot from the hip. I like to give it some thought.
Although, Your Honor, it's the reason it's new to the court is because this relates, Your Honor, to the same issues we've been litigating.
But not this specific issue.
No, but
You've not briefed this, so I'm not familiar with it.
No, Your Honor, what I'm saying though is that the court made very clear, if you remember, the last time we litigated the statement, I got very upset because I basically said, Your Honor, it's just Groundhog Day. We've litigated the same issue 6 times. So now the defense comes back under the auspices of, we're supposed to be looking at 352, and they introduce a new ground with no authority basically to support it.
Well, you're right. I mean, it is new. It was not supposed to be about this. I'm surprised, but that being said, I don't want to make an error, and so I certainly want to consider the argument. I understand why you didn't brief it, but the fact is, it's not. Mr. DeGuerin, will you yield to Mr. DeGuerin for a moment, some of your time?
Thank you. Unless I stand up and just try to say something, I'm afraid I'm not going to be able to get a word in edgewise. First, let me respond to this ridiculous assertion that there's no plea bargaining going on before a case is filed. It happens every day. In fact, that's what prosecutors, that's what cops do. They get somebody and they say, well, we might be able to help you if you'll help us, that kind of stuff. And actually, Mr. Lewin initiated this, and on page 22, at the top of the page, when he starts talking about, to Mr. Durst, what are your hopes? What are your hopes for going forward? What do you hope is going to happen? This is after Mr. Lewin has told him what a great prosecutor he is and how he always wins his cases. And keep in mind that Mr. Durst is in custody on a warrant from California that accuses him of murder. So the reality of the situation is that Mr. Lewin is holding the cards, and Mr. Durst then responds to it by saying, I'm 72 years old, I've only got 5 years to live. You can't do anything for me. What are you doing here? He says, I don't know how, I have no idea how we could reach an agreement on something, page 23. Obviously, Mr. Lewin is the one that brings up the subject of some kind of deal. That's plea negotiation. That's negotiating what the outcome of this confrontation is going to be, and it continues throughout that transaction, throughout that conversation. They come back to it time and again. So I think that viewing it as a whole, Mr. Lewin was leading Mr. Durst to believe that Mr. Lewin could make some kind of deal. Well, and he could. He had, and deals are made all the time without the lawyers.
So, let me, again suggest that we go to the original purpose of this motion, which is to examine this transcript through the lens of 352. I am going to read the authorities Mr. Lewin supplied. I've already read what you supplied. And then with that in mind, it'll be easier for me to review this transcript to see whether it fits any of the authorities.
I understand, Your Honor, and I'm sorry we don't have Mr. Ray here, who is our authority on California law, and he's ill and couldn't be here today. He might have been able to respond with some authority off the top of his head. Understanding that, what I'm hearing is we'll move on from what we believe were plea negotiations and shouldn't be in there, and what the court's already said preliminarily that you identified also, to the other issue, which is assertions of fact that cannot be cross-examined because Mr. Lewin can't be cross-examined.
I'm going to get to that in that idea as we address each line. I understand that contention that you're making. So we'll go. So Mr. Lewin, does that make sense?
Sure.
That I'll read
Sure.
I'll read your authorities and then we'll revisit this
That issue?
May we then, as far as the 352, my tentative will be in each direction throughout. So, in other words, there's some that I'm inclined to exclude and some I'm not. So let's.
Your Honor, if we can, I'd like to, if I can respond, I have each of his objections in order and our response to each of them, if I can, just for starting on that issue. What, they cited something they call factual assertions and opinions. That's not a legal ground.
Right.
The court's gonna treat it
You may be
as,
seated, Mr. Buchanan.
the court's
And so,
gonna treat it as 352.
Right, okay, so it doesn't fit perfectly.
But-
So
but-
so let me just preface where, to save you a little breath. All right, these statements of fact which amount to unsworn testimony. Typically, what that is, in the context of an interview, is Mr. Lewin confronting Mr. Durst with facts, okay? The facts that call out for some explanation. So, though he may be referring to some fact, that in and of itself is not going to be a basis for exclusion. And to the extent there is a problem, I am willing to cure any misconception with an instruction. There is a standard instruction that questions are not evidence. This is a little bit different because the question is in evidence, so a curative instruction may suffice.
Your Honor, before we
Yes.
go individually, I think it's just important on this area, I just need to let the court know that there are 3 points that are very important to keep in mind on this as we go through each individual objection. The
All
fir-
right, I have more also, but go ahead.
Okay,
On
thank you.
that particular
Yeah,
point about
on this
facts,
Yes, the first point is that everything that I asked him about, or that I brought up, was evidence that is actually in this case, one. Secondly, we are actually allowed, as the court is aware, I could make up evidence, which isn't even true and confront him with it, which I didn't. So everything, Your Honor, the court knows the case. There isn't one thing they can point to that I said, well, as an example of, Mr. Durst, you previously said X, or there's information that you pulled your wife, by the hair out of the Christmas party. Every single incident that I described is supported by the evidence in this case. Even more importantly, Your Honor, which is mind-boggling, Mr. Durst, his response to nearly every single thing that I said was, that's correct.
Yeah.
That happened.
Right.
I'm not denying it. So the issue that we have is, again, when you start looking at it, and the court's absolutely right, I think, with what the court is discussing, because Mr. Durst is adopting and accepting, sometimes from an implicit adoptive nature and sometimes explicitly, I'm saying to him, Mr. Durst, we have this evidence. And he is saying, yes, that's true, yes, that happened, etc. So the question does become evidence because he is adopting the answer. So in terms of specific objections, Your Honor, I went through on my list. So I know, for example, in this area, the first objection.
Well, let's save it till we go through it. I appreciate your general principle.
Okay.
I agree with it. Now, I think an interviewer can confront a suspect with something that is false. So somebody ratted on you and said you did it, or you failed the lie detector test, and that's acceptable ordinarily. Now, I'm not sure if a deputy district attorney conducting the interview ought to do that, but as you said, you did not, and so there's not a problem there. The second complaint is that the questions sometimes relate what a witness has said, and so the concern is hearsay. But again, this is like any other hearsay in two ways. One is that there may well be an exception, so confronting him for the purpose of explaining his response. In other words, it's not hearsay if it's not offered for the truth, rather to just present it for him to acknowledge, to adopt, or to deny, but it's appropriate. But again, to the extent anyone might have a misapprehension about it, it's not in that instance offered for its truth, but for that other purpose.
You know,
Now,
I would add, just so we're clear,
yes.
so we're not being disingenuous. When Mr. Durst was confronted with evidence in this case, and he adopts it, we are arguing that evidence comes in for its truth. Now, what helps us is that we have witnesses. I just want to make sure the court, when the court is saying we're not using it for a non-hearsay purpose, in other words, when he's confronted with, he is told, and we'll get into the specifics when we get there, and he adopts it, it's in, with no limitation.
If you adopt it.
Yes.
If you adopt it. And perhaps he does in each instance. I didn't scrutinize it from that perspective. Then, now, here's the difference. So the next complaint is that Mr. Lewin frequently stated his own opinion about defendant Durst's guilt, actions, or motivations. And I'm going to exclude that when I encounter it. So there are some bases for 352 exclusions. I think that is accurate. And then again, the other complaint is just a reiteration of what witnesses have said. Again, effect on the hearer, or if it's adopted, then it's for its truth. So let's go through them individually. That's just my tentative explaining, so I can use a shorthand after that. Yes, Mr. Chasnoff?
Your Honor, can we approach you for one moment?
Yes.
Thank you.